Good morning, Chairman Hughes and honorable members of the committee. My name is Jonathan Saenz, and I'm president and attorney for Texas Values. Texas Values is the largest nonprofit Christian law and policy organization in the state of Texas, and I'm here testifying in favor of Senate Bill 1073. As a lawyer myself, I have been licensed to practice law in the state of Texas for over 20 years. I've argued cases and been involved in cases at all levels of the court, and we've represented clients before the U.S. Supreme Court, Texas Supreme Court, and many of the lower federal courts, and also state laws and courts as well. And just about every religious freedom law that's been passed in the past 15 years in the state of Texas, our organization and myself individually, we've been a part of that. We've often represented clients on religious liberty issues, some may deem controversial. As the chairman laid out, there's been an ABA rule that was proposed several years ago. The State Bar of Texas has at times indicated that they might take action on this ABA rule 8.4G, which includes the words related to harassment and discrimination on sexual orientation and gender identity. We know that there is reasonable disagreement on these issues, particularly amongst Christians, and sometimes it comes out in court cases. Imagine a woman being forced to share a women's shelter with a biological man after escaping domestic violence and having nowhere else to go and being re-traumatized by that man's presence. That is a court case that happened in Alaska, and a lawyer was disqualified from representing that woman because of a rule like the ABA rule 8.4G. The DC Circuit has recently indicated they might take action and support this rule, and our friends at First Liberty Institute have expressed their opposition. Our Attorney General Paxton has spoken about this issue in disagreement with the ABA rule. And last session, a bill just like this passed the Senate with bipartisan support and also passed the House and died, if you will, and ended on the House floor. So we know that there's significant support for it again and a need. Even Chief Justice Jimmy Blacklock touched on this issue about the ABA rule and making it clear they're different than the Texas Bar. The ABA is a private organization. You're not required to be a part of it as a member of the bar, but they do wield significant amount of weight and influence. The Texas Bar is a public institution, and you're required as a licensed attorney to be a part of that bar. So there's a different distinction there. And at least from what I understood from Chief Justice Blacklock's comments, that he wants the ABA to be considered, their comments to be considered just like mine would as an organization that advocates and not carry any more weight. But we know that there are some people that want this rule enforced, and they would like to see Christian lawyers like myself never have the opportunity to represent and talk about these issues publicly when necessary in relation to representation of a client on issues related to gender identity, as I mentioned, or even be a part of a professional association or be at a Federalist Society event and maybe talk about some of these issues where there are healthy differences. And so that's what, I see that my time has expired. I'm happy to take any questions, but these are the many reasons why I'm here in support of Senate Bill 1073.